Hello again, Michael Farber for Farber Schneider Ferrari, here to give you another update from a recent firm win and a client victory we're very, very proud of. We recently learned that in opposition to a big motion that we filed was granted, and it dismissed the other party's entire case. Bit of background. We represent the defendants in a lawsuit that alleges $21.9 million owed arising out of the formation and operation and funding of a gold mine in Peru between two entrepreneurs and their affiliated companies. We represent the defendants. The plaintiff in this action sued our client for a series of promissory notes ranging between $1.4 and $2.1 million, and then another agreement acknowledging the aggregate debt of all those notes. They sued under a doctrine in New York State that allows for summary judgment in lieu of complaint, pursuant to CPLR 3213, which essentially tells the court, I'm owed a bunch of money, here's the promissory note, it's not conditioned on anything, it's a sum certain, payment hasn't been made, this is a clear and unambiguous promise, we don't need years of litigation or discovery or depositions, it's all right here in the note. And 3213 permits that lawsuit to proceed and to get a money judgment for the amount owed. It was our job to oppose and hopefully defeat this motion, and we recently learned that we did. How did we do that? We advanced three chief arguments. The first one was there was no personal jurisdiction over the defendant because he didn't have sufficient contacts with the state of New York and should not have been forced to litigate a matter in New York courts. Number two, the signatures on these purported promissory notes were all the same copy and paste electronic signature, and the authenticity of that signature was in question. Our third argument was that the annual interest rates in these purported loans were usurious, meaning they exceeded the allowable interest rate under New York state law. The judge actually rejected our first two arguments, but we won on the third, and that's all you need is to win on one argument. That's why it's important for litigation counsel in any matter to make all available claims or defenses or legal theories and arguments in order to prevail on a claim or a defense. Word to the wise on promissory notes and loans. In New York State, you cannot have higher than a 16% annual interest rate on loans of $250,000 or below. Between $250,000 and $2.5 million in a promissory note, you cannot exceed 25% annual rate. Loans beyond $2.5 million have no limitation on the usury rate. To have an excessive annual interest rate on any loan in New York State, that agreement will not be enforced by a New York court.